Good morning, ladies and gentlemen. First, welcome to the roundtable discussion on national security law, organized by the Law Society of Hong Kong, supported by the Academy of Law. The national security law, or in its proper name, the law of the People's Republic of China.
I have no sound.
Can you hear? Can you all hear?
Hannah, I don't have sound. I can't hear what they're saying.
Just stop freaking out.
Okay, let's proceed. The national security law, or its proper name, the law of the People's Republic of China, on safeguarding national security in the Hong Kong Special Administrative Region, 中華人民共和國香港特別行政區維護國家安全法 is no doubt one of the most important pieces of legislation for Hong Kong since the handover. It was added to Annex 3 to the Basic Law and was applicable to Hong Kong by way of promulgation by the Hong Kong SAR government on 30th of June 2020. The government said that the enactment of the national security law signifies the fulfillment of the constitutional responsibility of the Hong Kong SAR for the better institution of one country, two systems. In addition, the law also helps restore stability and prosperity in Hong Kong and paves the way to a brighter future. In response to the above, we have heard different views. Some said, yes, this is good. We finally have the law for the benefit of Hong Kong. Some said, wow. Some say, oh no, that is the end of the one country, two system policy. Some say, okay, let us wait and see. There are also some people who do not say anything at all and keep their mouths shut. Some check their passport and rush to the immigration agencies. The above mixed view clearly illustrate the implications and the importance of the national security law. The Law Society of Hong Kong today organizes a forum to provide a platform for the legal profession to exchange views and opinions on the legislation. We hope to contribute to the discussion on an informed basis. We are keen to hear from distinguished speakers to speak on various aspects of the national security law. And today, we have a full panel of very experienced speakers. You could see them in front of me. I'm certain there will be very fruitful discussion, and we'll all take home from the discussion valuable insights. May I express my sincere gratitude to all the speakers. Without further ado, let's get the forum started. Thank you.
Good morning, everyone. My name is Amir Ali Nasir, and I thank you all for coming, ladies and gentlemen. We have a distinguished panel of speakers today. We have heard our President, Ms. Melissa Pang, and we have the Honourable Ms. Elsie Leung. We have the Honourable Ms. Maria Tam. We have Mr. Ronnie Tong. We have Mr. Grenville Cross. We have Professor Hualing Fu, Professor Michael Davis as well, and he's joining us by Zoom. We have Mr. Thomas So, Mr. John Clancy, And we were to have Mr. Mark Daly, but he couldn't make it, but I hope that he can join by Zoom. We, Mr. CM Chan, and myself, Amirali Nasir, are going to be the moderators today. We have over 700 participants joining by Zoom, and some of this is relayed on live, is it? Yeah. So thank you everyone for attending, and I'll pass it to CM.
歡迎各位參加今日香港律師會主持嘅國安法論壇。當我哋設計呢個論壇嘅時候呢，我哋討論過呢個論壇應該係雙語進行嘅。原因係咩呢？大家都可能知道啦。港區維護國安法呢，就係6月30日係刊憲嘅。而英文版本咧就喺7月3日咧就係刊憲嘅，但係呢個英文版本咧係一個 translated copy 嚟，係一個翻譯版本嚟嘅。咁所以咧喺法律上佢唔係一個正式嘅文本嚟嘅。咁所以咧喺法庭將來要考慮呢一條條文嘅時候，始終係以中文版本為主嘅。咁大家亦都可以明白理解嘅，因為呢條法例咧係人大常委通過嘅，就唔會有一個正式嘅英文版本嘅。咁所以經過內部討論咧，我哋覺得咧係應該用雙語去討論今日個論壇嘅。咁我哋亦都有即時嘅傳譯嘅。咁所以咧由聽眾又好或者嘉賓都好咧，都係好任佢哋選用邊一種語言，英文或者中文都可以嘅。咁我講嘅係咁多啦，多謝各位。我俾翻阿 Amir 我同事去繼續。
Yes. Thank you very much. Those John Clancy and Professor Mr. Granville Cross, you have earphones for free, so if you want translation, it's available. Yep, you have it as well, John. So we'll start off. May I? Also, I seem to be the only one that seems to have a kill switch. That means I can stop everyone speaking, but I notice nobody else has that. So we've given everyone 5 minutes to speak. Notice that I have this switch. So can I start off by asking the Honourable Miss Elsie Leung, who's GBM JP, who's a former Deputy Director of the Hong Kong Basic Law Committee of the NPCSC, of the PRC, and the former Secretary for Justice of the Hong Kong SAR government. Miss Elsie Leung, thank you very much.
Thank you, Amrali. Good morning, ladies and gentlemen. Because of the time lot given, I will speak. I will offer my general comments on the law, which is the law of the PRC on safeguarding national security in Hong Kong SAR, that was passed by the Standing Committee of the NPC on the 30th of June, and it came into effect by promulgation on the same date. What happened in Hong Kong for the past 13 months shows that it was not just social unrest that caused the havoc and social instability in Hong Kong, as what was behind the riots and disturbances were the sinister desire to separate Hong Kong from China and to subvert the Central People's Government, engaging in terrorist acts and collusion with foreign countries and external elements to endanger national security. The only way to stop the riots and disturbances would be to remove the cause of such acts and behaviors. There was, until now, no law or enforcement mechanism to deal with this kind of offenses, and the promulgation of the law is timely for preventing, suppressing, and punishing this behavior and actions and acts. Now, the law confirms the Central People's Government's decision to ensure the resolute, full, and faithful implementation of the policy of one country, two systems, under which the people of Hong Kong administer Hong Kong with a high degree of autonomy. This is stated in Article 1 of the law. It places the Central People's Government's overall responsibility for safeguarding national security and the constitutional duty of Hong Kong SAR in safeguarding national security in appropriate levels, thereby reflecting Hong Kong's legal position as a local administrative region of the PRC that comes directly under the Central People's Government in accordance with Article 12 of the Basic Law. The law embraces Hong Kong SARG into overall governance of the Central People's Government in the matter of national security, which affects every inch of its territory, whilst fully recognizing Hong Kong's high degree of autonomy, as reflected by the fact that the Central People's Government has not applied the national security law passed in 2015 to Hong Kong, but enacted a special law for Hong Kong to fulfill its obligation to safeguard national security. It has resolved a matter which Hong Kong itself has not been able to resolve during the past 23 years, and has achieved an even convergence and conformity between the relevant national law and the Hong Kong law. It is an important milestone in the implementation of the one country, two system since the institution of the interpretation of the basic law was established. The law does not weaken the principle of high degree of autonomy. It reaffirms Hong Kong's responsibility to complete as early as possible legislation for safeguarding national security as stipulated in Article 23 of the Basic Law. Actually, Hong Kong SAR is obligated to enact laws not only in accordance with Article 23, but also as and when necessary to take all necessary steps to safeguard national security. That is because of our constitutional responsibility under Article 54 of the Constitution and the Articles 11 and 40 of the National Security Law of the PRC, although it is not included in Annex 3. What the law has covered is mainly the 4 types of offenses and activities which endanger national security, and the law, Hong Kong legislature is unlikely to achieve within a reasonable period of time. It fully respects Hong Kong's autonomy to enact legislation. Insofar as the administration is concerned, the Committee for Safeguarding National Security comprises only Hong Kong people. That is, the Chief Executive, the Chief Secretary, Financial Secretary, the Secretary for Justice, Commissioner of Police, Director of Immigration, Commissioner of Customs and Excise, and the head of the newly formed Department for Safeguarding National Security in the police force, and the Director of the Chief Executive's Office. That is stated in Article 13 of the law. The committee has an advisor, namely an official designated by Central People's Government, who is Mr. Lo Hui-ling, the Director of Liaison Office in Hong Kong of the Central People's Government. But as consultant, he has no executive power but to give advice, and that's Article 15 of the law. Hong Kong SAR shall have jurisdiction over cases concerning offences under the law, except the extreme small number of cases provided for in Article 55. And the laws of Hong Kong shall apply to procedural matters, including those relating to criminal investigation, prosecution, trial, execution of penalty relating to offences under the law. Such cases to be tried on indictment. That is Article 41. There are, of course, already provisions in our law to protect national secret and sensitive matters. For example, hearing in camera, prohibition of disclosure of sensitive information and documents, regulation on intrusive investigation, etc. But they are already existing in our legal system. And with such, this will be applied with modification as are necessary. All these show that Central People's Government fully respects Hong Kong people running Hong Kong. Regarding the Office for Safeguarding National Security of the Central People's Government in Hong Kong, its main functions are to analyze and assess the development and providing opinion and making proposals on major strategies and policies for safeguarding national security, overseeing, guiding, coordinating with, and providing support to Hong Kong in the performance of its duties, collecting and analyzing relevant intelligence and information, and handling cases concerning endangering national security in the extreme small number of cases which I mentioned. If there is in those cases which it assumes jurisdiction. In the execution of its duties, it must not injure lawful rights of Hong Kong citizens, legal entities and organizations. That is Article 4 of the law, and Articles 7, 47, and 83 of the National Security Law of the PRC. The law aims at preventing, suppressing, and imposing punishment for the offenses of secession, subversion, organization, and penetration of terrorist activities, and collusion with a foreign country or with external elements to endanger national security. Our friend here, Professor Hualin Hu, will be dealing with these offences in greater details. Any imperfection of the law may be resolved through Hong Kong courts in the administration of justice. There may be challenges in the beginning, but difficulties are not insurmountable. The International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, which are referred to in Article 4 of the law, were extended to Hong Kong in 1976, but no law was enacted to implement them until 1991, when the Hong Kong Bill of Rights Ordinance was promulgated. It took about 6 years for the disputes in interpretation of the ordinance to be settled. In 2011, the Secretary for Justice, in response to questions by members of Legislative Council, said that about 1,000 judgments have been made references to it, which shows that it shows the reliance people have on it, despite the early controversies. There are adequate common law precedents for judges to rely on in interpreting the interpretation of statutes. For example, how serious is a serious crime? A well-established system for interpretation of statute exists in Hong Kong, and courts are fully competent in interpreting the law. Nor do our courts lack the ability for interpretation of laws of other jurisdictions. Considering the necessity of the law, we should make every effort to ascertain the true meaning of the law and make it work instead of putting obstacles to hinder our own progress. May I conclude by asking whether you have had your fundamental rights and freedom infringed upon by the government since 1997? Do you have faith in our judiciary? The World Justice Project ranks Hong Kong's rule of law the 16th amongst 128 jurisdictions globally and 5th out of 16 jurisdictions in East and Pacific region. More than half of the people in Hong Kong consider one country, two systems the best choice for Hong Kong. Do you also think so? I would ask you to have confidence in our own legal system, which has proven to be robust in the past 23 years. Thank you.
Thank you very much, Elsie.
多謝梁偉詩女士嘅精彩演說。我哋下一位講者係譚慧珠女士。譚女士係中華人民共和國全國人民代表大會香港特別行政區基本法委員會副主任。有請譚女士。
多謝主席。我要用中文講，因為大部分我要用嘅詞語咧都係中文。我係咧負責講3件事。第一咧就係憲法同基本法、憲法同國安法嘅關係。第二咧就係國安法同基本法嘅關係。第三咧就國安法同香港本地法律嘅關係。咁喺我哋6月30號嘅時候咧，就香港基本法委員會咧就按基本法第18條咧，就向人大常委會咧係俾意見，可唔可以將佢咧係經過附件3納入咗之後咧，喺香港咧係公佈實施，成為香港法律嘅一部分。咁我哋嘅建議咧係可以嘅。我哋考慮咧係3點：第一，佢是否屬於國防？咁唔係啦。係咪外交？唔係啦。第三咧就係香港嘅高度自治權以外嘅事情。咁我哋嘅答案咧就係嘅。主要嘅原因咧就係呢個係行使主權嘅問題。任何一個國家，無論佢係單一體制嘅國家或者係聯邦制嘅國家咧，係負責制定呢啲法律同埋設定呢啲執行嘅方法同埋機關咧，都係喺佢自己嘅中央政府同埋最高嘅立法機關嘅。咁所以咧，中國咧亦都唔會例外。呢個係中央嘅事權。第二點，我哋考慮到咧係基本法第23條。本來咧就話香港應自行立法處理7宗嘅事項，咁我哋睇到佢係寫喺基本法嘅第2章中央地方關係。我喺1985至90年嘅時候咧，亦都係基本法嘅草擬委員，我就係喺中央地方關係呢一組有參與咧係寫第23條。當時嘅考慮咧，就由於中國嘅刑法咧係有一個反革命罪，我哋認為難以處理， 咁情況之下，有其他好多事咧係要將嗰個草擬咧係完成。咁於是咧就俾香港一個自行立法嘅機會咧，去解決呢啲問題。並唔係咧就將中央呢個事權咧係永久放棄咗俾香港一個國家咧，最後呢個責任咧都係中央政府嘅。咁可惜咧，過咗23年之後咧，我哋都冇立法，同埋咧就繼續落去啦，可以立法嘅機會咧係仍然係咁淡。咁因此咧，中央政府睇到香港近年來發生嘅好多情況咧，確實需要咧係有一個安定嘅社會嚟到繼續使一國兩制可以咧係行落去。咁於是咧就決定咧就係要為香港咧係立國安法。咁因此我哋嗰個建議咧就係可以納入附件3喺香港公佈實施。咁憲法同埋基本法嘅關係，大家都好清楚啦，係人大係按住咧係第31條嘅憲法咧，就可以成立特別行政區裏邊嘅制度，以法律規定之，就係變咗係我哋基本法啦。同埋人大咧，亦都可以咧根據憲法第62條第14項咧，就設定特別行政區裏邊嘅制度嘅。咁我哋回歸之後咧，好些嘅決定咧都係按呢個嘅憲法呢一條咧嚟到處理嘅。咁憲法同埋咧我哋而家講呢個國安法嘅關係咧，就係憲法第2條咧就話國家行使權力嘅機關咧係全國人大大會。咁跟住佢就話咧喺第28條咧就係國家要維護社會秩序、鎮壓叛國或者其他危害國家安全嘅犯罪活動等等。咁因此憲法嗰度咧係講得好清楚，最高嘅權力機關咧係人大，而咧憲法裏面講咧國家一整個國家咧都要維護國家嘅安全嘅。咁同埋咧就係佢話中華人民共和國有維護國家統一同埋各國各民族，對唔住，同埋國家各民族團結嘅義務。呢個憲法第52條，然之後憲法第54條咧就話中國嘅公民咧有維護國家安全、榮譽利益嘅義務等等。咁因此咧係國安法咧係完全符合憲法裏邊咧係對一個中央政府同埋咧係國民嘅要求嘅。咁呢個咧就係國安法咧同埋憲法嘅關係。咁比較難處理啲嘅咧就係國安法咧同埋基本法嘅關係。咁就我哋知道咧係冇一條法律寫咗之後咧係唔會打官司嘅，一定有灰色地帶。咁樣咧，我就盡量咧係簡單咁樣概括咁樣咧係介紹一下我理解佢哋兩者嘅關係。第一咧，佢哋兩者都係全國性法律，全國人大代表大會立嘅法係全國性法律，基本法係其中之一。大會授權常委會立嘅法律，亦都係全國性法律。呢個咧就係國安法。咁佢哋嗰個法律地位咧，喺中國嚟講咧，就喺憲法之下，喺其他法律之上，而係完全咧係平排一致嘅。咁所以咧，我哋就唔可以話因為基本法咧係我哋認為香港憲制嘅文件，咁其他所有嘅嘢入咗附件3咧，你就變咗佢嘅附屬法例。國安法咧唔係基本法嘅附屬法例。咁佢哋兩個既然係平排嘅話，大家係點樣決定有冇違背嘅情況咧？咁啊，首先咧就係憲法與法律委員會同埋咧係法工委咧係已經研究過呢個問題，認為兩者冇違背。基本法委員會咧亦都咧係研究過呢個問題咧，認為兩者冇違背嘅。咁主要嘅原因係乜咧？就係國安法咧就係補足基本法第23條造成嘅或者存在嘅一個缺陷，佢並不替代基本法。因此咧，我哋仍然喺香港咧有個憲制責任咧，要為第23條立法嘅。咁如果有人問我可唔可以喺法庭嗰度咧係提出訴訟，認為咧係國安法違反咗基本法啊？咁我咧就要同大家咧係講清楚啦。咁你會睇到咧喺基本法裏邊咧係有一啲條文咧，就話有一啲嘅法律如果抵觸基本法嘅話咧， 就我哋嘅法庭咧係可以不給予呢個法律嘅效力，甚至有人講咧係有違憲審查權。咁但係其實我哋睇真啲咧，我哋嘅法國基本法嘅條文咧係冇一條話我哋可以去法庭嗰度咧就話另一條嘅全國性法律咧係抵觸基本法。嗱，基本法第8條咧就話香港原有嘅法律，即係普通法、衡平法等等啦。如果抵觸基本法嘅話咧，對唔住，除咗同本法相抵觸或者經立法機關修改外，其他都保留，即係原有法律等等咧，係除咗抵觸基本法或者立法機關修改咗之後咧，全部保留。咁然之後第7條咧就係香港立法機關制定任何嘅法律，如果唔符合中央地方關係嘅中央管理嘅條款咧，又可以發回重議。咁然之後第11條咧就話香港特區制定嘅任何法律咧，均不能同本法相抵觸。咁160條咧就話香港原有嘅法律，除咗經過人大常委會宣佈為本法抵觸者外，就採用為特區嘅法律。如果以後發現咧呢個法律仍然同基本法抵觸咧，可以依本法規定嘅程序修改或者生效。呢4條可以話同基本法抵觸嘅法律咧，都係講香港本地嘅法律同基本法抵觸。係冇一條喺基本法嘅條文咧，係話可以去審是否一條全國性嘅法律同香港抵觸嘅。咁全國性法律之間，如果互相認為有矛盾，嗰個解決方法係點咧？個解決方法咧就喺立法法嘅第94條第1款。佢話法律之間咧，同一個事項，新嘅一般規定同舊嘅特別規定不一致咧，唔能夠確定點樣適用嘅時候咧，就由全國人民代表大會嚟到裁決啦。如果兩個全國性法律互相認為有矛盾咧，最後咧就由人大咧嚟到裁決。咁呢個就係我哋嘅國安法同埋基本法其中一個要比較要清楚嘅地方。咁但係咧唔係等於國安法咧同基本法係冇關係。大家知道啦，佢係經附件3嗰度咧係入基本法入香港咧係頒布實施啦。咁另一方面咧，基本法第84條咧就話呢一挺嘅法律咧可以喺香港咧嘅法院咧去作為審判嘅。咁下邊跟住一個問題咧就係我哋法院審判嘅時候可唔可以用第158條第2款啊？咁呢個咧就係同大家講一講，即係我自己個人嘅理解啦嚇。你會睇到咧，就喺國安法裏邊咧係講得好清楚咧，第65條咧就話本法嘅解釋權咧屬於全國人民代表大會常務委員會啊。咁然之後咧就冇寫到158條嘅相類似嘅條文咧喺國安法嗰度嘅。咁係咪等於如果你係睇國安法或者審國安法，香港嘅法院唔可以解釋國安法咧？個答案就唔係，因為第84條咧已經話咗咧，法院係可以將喺附件3引入嘅全國性法律咧愛嚟審案嘅。咁因此咧係158條2咧係仍然咧係有效嘅。咁同時咧就係講一講全國性嘅法律咧，唔係淨係香港嘅法院可以提出修改嘅。人大常委當然可以提出修改啦。但係解釋方面咧就一定係人大常委會啦。咁如果有其他嘅方面提請人大常委會去解釋咧，人大常委會亦都會做嘅。大家知道我哋係回歸之後咧就釋法做咗5次啊，其中都有一次係光果金嗰件案咧，係我哋嘅法院用158(2)提出嚟嘅，其他嗰4個咧都係特區提出嘅。咁所以咧就向大家提一提咧，就係第65條嘅意思咧，即係話除咗法院之外咧，其他方面咧，包括香港政府咧都一樣可以提出咧係要求解釋嘅。 咁另一個係有相關嘅咧，就係剛才梁女士講係有關第4條係呢個人權自由嘅問題啦。咁樣就基本法第39條裏邊話2個公約適用於香港嘅保障咧係繼續嘅。咁呢一點咧就喺國安法寫咗出嚟啦。咁另外咧就國安法第5條咧，亦都講咗咧係刑事受嫌人嘅權利咧，亦都保障到嘅。咁最後一點咧就係講即係有關呢2條法律嘅關係嚇。呢個係我自己嘅睇法啫嚇，亦都唔係即係有啲乜嘢嘅文件話研究出嚟嘅。我哋睇到咧有3種嘅案咧係中央可以審嘅。第一咧，佢就係涉及外國或者境外勢力嘅複雜情況嘅案啦，咁就特別行政機關係有困難。第二咧，就出現香港政府無法有效執行本法嘅嚴重情況咧。第三就出現國家安全面臨重大現實威脅嘅情況啦。咁其實咧就我覺得呢3類嘅案件咧，佢嗰個後邊嗰個理念咧，係同我哋基本法第18條同埋19條咧係相近嘅，就國防外交等國家行為同埋咧就係如果香港有啲動亂咧，我哋自己唔可以控制，咁情況之下咧，甚至咧係國家嘅全國性法律咧都可以嚟香港實施。咁呢3類嘅案件咧，其實你望落去咧就係屬於呢類性質嘅。咁就我喺呢度咧就先講一句嚇，即係我未講到同本地法律嘅關係，就先講一句，即係有一個好大嘅點講啊，一個評論啦嚇，就話呢一次咧，我哋係冇咗一國兩制，我哋變咗一國一制。其實呢個法律國安法本身咧就係體現一國兩制嘅。第一咧就係有關所有呢啲國家安全嘅事權咧，根本係唔屬於香港。咁但係咧喺呢個法律裏邊咧，你發覺除咗第5章係講中央方面管轄嘅事咧，其他嗰4章咧有一啲係直情係香港自己管嘅，有一啲咧係大家可以共享嘅，互相協助嘅。呢個係一國兩制。第二點咧，就絕大部分嘅案件咧都係喺香港審嘅。咁大家記得Catalonia 嗰個案係一個自治區，佢個國會咧就係決定咗咧係要獨立。咁但係咧西班牙嘅中央政府，西班牙嘅中央政府咧就將呢一批嘅領導人士咧冚唪唥請咗去馬德里嗰度審嘅。咁但係咧，我哋呢度絕大部分咧都係完全香港自己處理嘅。呢個咧亦都係一國兩制。第3點咧，亦都一國兩制咧，就係中國嘅國家安全法咧係有12方面嘅。呢個包括政治、軍事、經濟、文化、社會、科技、資訊、生態等等等等等等。咁但係咧，佢只係喺呢度咧係處理咗4個方面。佢4個方面咧就分裂國家，我哋係冇呢個法律嘅。同埋咧係顛覆國家政權，我哋亦未有呢個法律。咁另外2個咧亦係香港面對嘅問題。咁所以咧，我希望咧就係認為呢一次嘅舉措係令到香港咧變成一國一制咧，係喺呢個法律即係國安法裏邊咧係睇清楚，我哋仍然咧係一國兩制。咁最後咧就講到國安法同我哋自己本地法律嘅關係。咁首先咧就係你會睇到咧就話62條嗰度咧國安法話，如果本地嘅法律咧同國安法有抵觸嘅話咧，就國安法為準啦。咁係佢有一個凌駕性嘅。咁你知道即係喺法律嘅檔次咧，佢係一個全國性嘅法律嚇。咁就亦都喺第14條嗰度咧就話係嗰個維護國家安全委員會嘅決定咧係不受司法覆核嘅。呢個情況咧就係等於咧係乜嘢咧？就係我哋喺5日前出嗰啲細則咧，本身都係不受司法覆核。咁但係執行呢啲細則嘅警務人員， 一定係會可以咧係受司法覆核。咁多謝大家我就講咗咧就憲法同呢兩個法律互相之間同埋國安法同埋香港本地法律嘅關係。多謝主席。
多謝譚慧珠女士嘅精彩解釋。關於憲法、國安法同埋基本法三者，仲有本地香港嘅法律啦，當然四者嘅關係係非常之精彩嘅。多謝。我哋下一位講者咧就係湯家驊資深大律師。咁我都唔需要介紹啦。湯大律師就係行會成員啦。咁我就將個時間交俾湯大狀。
多謝主持。不過首先我想聲明咧，我今日出席係以個人身份，我嘅言論並不代表特區政府。第二咧就係我係會從一個律師嘅角度去討論今日嘅議題。咁就我盡量會避開一啲即係可能會引致一啲情緒方面嘅政治嘅敏感嘅問題。我今日想講講咧就係國安法對於香港高度自治嘅關係。大家可能留意到咧，喺國際間咧，自從通過咗呢條法例之後咧，我哋係遭受到前所未有鋪天蓋地嘅批評。好多外國嘅專業團體，包括律師嘅團體，一啲外國嘅傳媒，特別係外國嘅政府咧，都異口同聲咧，就係話呢條法例咧係損害咗香港嘅高度自治。咁所以我想就呢個問題咧，簡單講講我嘅睇法。第一咧就係損害高度自治咧，我哋可以分開兩個層面去討論嘅。第一個層面就係立法過程，第二個層面咧就係法律嘅內容。我哋先講講立法過程先。好多外國政府咧就話呢個立法咧係損害咗香港嘅高度自治，甚至係有違中英聯合聲明。我希望大家咧都攞中英聯合聲明嚟睇睇，唔係好長嘅啫，幾版紙嘅啫。其實裏邊係冇提到國家安全呢個問題，完全冇提到嘅。第二咧就係、如果你將香港嘅高度自治等同可以完全代表中國去通過任何有關國家安全嘅問題咧，我覺得呢個睇法係相當即係違反常理嘅。國家安全係整個國家嘅問題。而國家安全咧，亦都係涉及中港關係嘅問題，好明顯就唔係香港高度自治嘅範圍之內。從呢個層面睇咧，就係基本法本身有提到第18條咧，係可以即係透過呢個附件3引入呢個全國性法律。咁即係換句話講，喺一國兩制嘅設計嘅時候咧，其實已經預留咗全國性法律係可以透過某一個程序咧喺香港實施。咁既然係已經預留咗一個咁嘅情況咧，我又睇唔到點解呢個立法嘅過程咧係可以被視為一個違反一國兩制或者係違反呢個中英聯合聲明嘅一個處理嘅方法。至於法律嘅內容咧，我想簡單講講咧，就係話條例嘅第4條。確立咗香港2條人權公約繼續係有效。第5條確立咗香港嘅一般法治嘅原則係繼續有效。咁呢2條條文好明顯係一個即係重申一國兩制嘅指標嘅一個重要嘅條文。我哋大家唔可以隨便係忽略咗呢個2個條文。咁另外咧，我哋都要睇到第8條。第8條講咧就係話特區咧係執法。有責任執法，切實執行本法和特區現行嘅法律。呢個係對於國家安全嘅法律。咁呢個又係一個好明顯嘅界定咧，就係話呢條法例、呢條全國性法律喺香港實施嘅時候咧，個執行嗰方面咧係香港嘅特區政府、香港嘅司法系統咧係負責執行。如果我哋再睇睇第40條咧。呢個更加明確講講香港特別行政區對本法規定的犯罪案件行使管轄權，但本法第55條規定除外。咁即係話咧，所有嘅執法咧都係由香港嘅制度去執行嘅。既然係咁咧，好明顯呢個係符合香港嘅高度自治嘅其中一個 重要嘅指標。咁唯一嘅例外就係第55條。咁所以我哋就需要睇睇第55條咧，係有冇一啲情況係會影響到香港嘅高度自治嘅問題。頭先譚慧珠女士咧，其實都已經觸及過呢個問題，解釋過咧裏邊所謂嘅高度裏邊所謂嘅特別嘅情況咧，係一種即係非常特殊嘅情形。但係作為一個律師咧，我哋大家都明白咧，我哋都希望呢啲越係特殊嘅情形咧，係越係需要仔細咁去寫清楚理念，係要清晰地表達到出嚟。如果我哋睇第55條咧，其實3個情況咧，我哋最關注可能係第一個情況，就係話案件涉及外國或境外勢力介入的複雜情況，令到特區嘅管轄咧係有困難。嗱，其他嗰2個情況係一種普遍嘅情況，唔係指一個個別案件嘅情況。而嗰個普遍嘅情況咧係即係嚴重到我相信大家都唔期望或者係唔會預料到咧係會發生嘅。咁所以我哋簡單可以略過嗰其他2個情況。但係第一個情況咧係針對個別案件，咁所以我哋要小心去睇睇。第一個問題出現咧就係何謂介入？喺我哋呢條法例之下咧，我哋有一條罪名咧就係勾結外國勢力。好明顯，當你勾結外國勢力嘅時候咧，必然有外國勢力介入。咁係咪所有勾結外國勢力嘅案件都要受55條呢個特別情況去處理咧？我相信唔係嘅，因為呢個即係同頭先我哋講嘅即係一般嘅第4條、第8條同第40條所提及嘅管轄權咧，係會有相違背。咁所以我係個人傾向咧，係指一啲特別嘅情況。咁所以喺呢方面咧，我係期待咧係人大常委會咧係會喺呢方面揾一個適當嘅場合咧去解釋、補充解釋。呢個介入咧係指犯罪嘅行為嘅介入啊，定話處理案件嘅時候嘅介入？嗱，如果係處理案件嘅時候介入咧，我係明白嘅。例如出現咗一件案件，美國政府係有好大反應。甚至乎採取啲行動去阻礙呢個案件嘅審核，或者影響香港嘅審判嘅過程嘅話咧，咁呢個涉及呢個外交嘅情況咧，係屬於我哋自治範圍之外，由中央去處理咧，呢個係合適嘅。咁所以我哋一定要睇睇嗰個介入嗰個理解應該係點樣樣。至於你話複雜情況同埋確有困難咧，呢個都係一個我哋叫做即係判斷式嘅字眼。咁我哋都希望咧係有機會咧係中央政府咧係喺佢點樣作出批准呢個特殊情況嘅出現咧，係講出一啲基本嘅原則或者門檻，令到香港人或者國際社會咧係更加容易理解到咧第55條1所提及嘅問題咧，係一個非常非常之特殊嘅問題，唔係一般嘅案件嘅問題。第二點有關55條，我想提及嘅咧就係第56條同57條咧，係提及到若果呢個特殊情況出現嘅時候咧，嗰個案件係會由呢個內地嘅制度咧、法律制度咧係去處理。嗱，首先我覺得呢度咧要小心去睇睇。第55條嘅第1款嘅開始嗰個段落咧，佢有提及到由國家安全公署對本法規定的危害國家安全犯罪案件行使管轄權。換句話講咧，公署所行使嘅管轄權咧，係依條法例嘅罪行嘅管轄權，即係唔係內地其他法例或者係對甚至乎有關國家安全嘅案件嘅管轄權。咁即係話，當你要審呢件案嘅時候咧，嗰個罪行必須要係依個條例之下嘅罪行。個定義亦都根據呢個條例嘅定義進行審核。而我哋頭先所講嘅第4條、第5條有關國際人權公約同埋呢個法治嘅原則嘅條文，亦都應該係適用。亦都係應該係尊重。第3點我想講嘅咧就係第57條咧 係有提及到如果係由呢個公署去接手管轄呢件案件嘅時候咧，內地嘅中華人民共和國刑事訴訟法等相關法律嘅規定係適用。我嘅理解就係依條條文所涉及嘅係啲程序上嘅規定。我嘅理解係中華人民共和國刑事訴訟法係一個程序法，唔係一個實體法。而我哋而家睇緊呢條國家安全法咧，係一個實體法。咁即係話咧，程序上係要根據內地嘅審判嘅程序去進行，但係引用法律同埋點樣去定罪咧，係依然跟隨翻我哋而家呢條嘅國安法係去進行。嗰個審判咧係審判呢條條例之下嘅罪行，個審判唔係審判一啲其他嘅罪行。咁所以呢個咧亦都係完全係尊重同埋體現一國兩制嘅一個，我相信係一個相當特別嘅安排。咁但係我頭先所講嗰3方面咧，其實都係存在爭議性嘅，而國際社會亦都就此咧係提出咗好多質疑。咁我係好期待咧，係喺適當嘅情況之下咧，中央同埋特區政府咧喺呢方面咧係會多加解釋，釋除呢個國際間嘅疑慮。多謝。
非常多謝湯大狀嘅解説啦。咁我都補充一句咧，其實大家今日在座嘅與會人士咧，都係講佢嘅個人意見嘅，我哋都唔係代表任何團體或者組織去發表任何聲明嘅。咁我就交俾 Amir 下一位講者嘅介紹。Next speaker, you do the next speaker.
Yeah. Thank you, Sam. May I now invite Mr. Graham Cross, SBS, SC, is the Vice Chairman of the Senate of the International Association of Prosecutors and former Director of the Public Prosecution of the Hong Kong SAR Government. Mr. Cross, please.
Thank you very much indeed. I should like to address 5 very practical areas which will arise, I believe, in the very near future as and when the prosecutions get underway. The first issue is the prosecution of offences by the Department of Justice. Although the Article 18 of the new law requires the Department to create a specialised prosecutions division to be responsible for the prosecution of offences endangering national security and related legal work, this division will still apply the usual criteria to prosecutions, namely, is there a reasonable prospect of conviction on the available evidence, and is it in the public interest to prosecute, such being the criteria which are applied throughout the common law world. However, there are areas which need clarification. On its face, these national security law cases can only ever be conducted by specialist prosecutors at the advisory stage, at the trial stage, and at the appeal stage. So this means that the Department's appellate specialists who handle the most important cases, which go to the Court of Appeal and the Court of Final Appeal, will be excluded from dealing with security cases, unless, of course, they are seconded to the new division. It will also mean that lawyers from the private sector who conduct many cases at the moment on behalf of the Department will not be eligible to prosecute cases of this sort. So this will mean that the new division will need to have a strong advisory capacity as well as a strong advocacy capacity, although the use of part-time members may offer a way forward, particularly if the number of security cases is not great. However, any such part-timers will need to come, I would have thought, from within the department itself and not from the private sector unless they are specially recruited. Another important issue for prosecutors concerns the joinder of offences. It is a basic procedural imperative at the moment that when offences arise out of the same incident, they should all be consolidated and tried together, not least because this avoids a duplication of proceedings with witnesses having to testify twice about the same matters. One can, however, readily imagine cases where there are multiple charges available against a suspect, but only one involves national security. For example, someone who is indulged in secessionist activity may also be charged with wounding a police officer with intent and unlawful possession of a firearm. And this is problematic, as the secessionist charge is subject to the national security law procedures, whereas the other two are not, and consolidation may not be possible. So the question therefore arises which charge or charges should take precedence. One possible answer, of course, is to have two separate trials, however undesirable that may be, with the most serious charge being tried first. In this scenario, I suppose, a final decision on proceeding with a second trial on the other charges could be deferred until the result of the first trial is known. The second area concerns the trial of offences. The new law, Article 41, subsection 3, provides that cases concerning offences endangering national security within the jurisdiction of the HKSAR shall be tried on indictment, and the significance of this requires recognition. As to what is meant by that term on indictment, the Criminal Procedure Ordinance, section 14A, states it means, quote, the offence shall be triable only upon indictment. Although there are exceptions, as where an offence may be triable either summarily or upon indictment, these do not apply to Article 41, subsection 3. So what this apparently means, therefore, is that security offences, even if in the lower category of seriousness, will need to be tried in the court of first instance of the High Court. Although the Magistrates' Ordinance, section 92, certainly enables magistrates to deal with indictable offences, this only arises in a situation where the Secretary for Justice can elect to have an indictable offence tried summarily. However, the Article 41.3 does not confer any power on the Secretary for Justice to elect to try an indictable offence in the Magistrates' Court. And Section 2, moreover, stipulates that where an indictable offence is triable summarily, the maximum sentence is 2 years' imprisonment and a fine of $100,000, unless any law states otherwise. And Article 41.3 makes no reference whatsoever to the sentencing of defendants for national security offences which have been tried summarily. And even though the District Court Ordinance, section 75, enables the District Court to try indictable offences transferred to it by the Magistrates' Court, where this is expressly provided for, the trial which results remains a summary trial, as it is in the Magistrates' Court, and is not a trial on indictment. Although it is certainly true that Article 45 enables the lower courts, including the Magistrates' Court, to, quote, handle proceedings related to security cases, this in context and in light of Article 41.3 can only mean processing the initial arrest cases, attending to preliminary matters such as bail, and conducting committals to the higher courts. In any event, the opening words of Article 45 make clear that the references to courts handling security cases is to be read subject to what is otherwise provided by this law, which can only be a reference to Article 41.3's stipulation that all national security law cases are to be tried on indictment. So this, I suggest, is an area which will require clarification in the very near future. Now, the third area concerns the trial of offences by a three-judge panel, which is provided for by Article 46. Although in straightforward cases it will be possible for a jury to try a national security law case in the ordinary way, Article 46.1 entitles the Secretary for Justice to issue a certificate directing that the case shall be tried by a panel of three judges instead of by the jury, on the grounds of, among others, the protection of state secrets, involvement of foreign factors in the case, and protection of personal safety of jurors and their family members. Now, the inclusion of the term among others suggests that these examples are not exhaustive, although it is not immediately clear what other situations might justify a three-judge trial. However, when there is a three-judge trial, there is no indication at present of the procedures at trial. Will the three judges need to be unanimous, or will a verdict of 2-1 suffice? Will they have to provide reasons for verdict in the same way as is done by a district court judge? If one judge dissents from the verdict of the other two judges, should he or she give reasons, as happens, for example, in the Court of Appeal? Now, if it be right, as appears to be the case, that all national security law cases have to be tried in the court of first instance, these issues will require resolution in the very near future. Unless there is to be expedited legislation governing the procedures to be followed, one viable solution might be for a practice direction to be issued by the Chief Justice as to the practice and procedure to be followed by the court, pursuant to Order 1, Rule 4 of the Rules of the High Court. And as to the inherent jurisdiction to regulate criminal procedure by means of practice directions, Lord Devlin, in the famous case of Connolly and the Director of Public Prosecutions, said that it was open to the higher judiciary to make and enforce rules of practice in order to ensure that the court's process is used fairly and conveniently, adding that the general power to prevent unfairness to an accused has always been part of the English criminal law. And indeed, in the Australian case of the King and the Commonwealth Court of Conciliation, the High Court of Australia approved this proposition that, in 1950, that if jurisdiction is conferred upon a court, it may and should exercise that jurisdiction. And if no procedural machinery has been provided, it is for the court to provide such machinery as best it can. And this, I suggest, is a possible remedy. The fourth matter is bail to suspects under Article 42, subsection 2, which provides that no bail should be granted to a criminal suspect or defendant unless the judge has sufficient grounds for believing that the criminal suspect or defendant will not continue to commit acts endangering national security. In other words, the accused person will need to satisfy the judge that he will not commit any such acts if granted bail. Now, if he does that, does it mean that he will then necessarily be granted bail? I suggest not, and logic suggests that this is an extra hurdle for a bail applicant to overcome, and it does not replace the existing bail criteria. As the Criminal Procedure Ordinance Section 9G indicates, there are three bases currently for denying someone bail. Namely, whether there are substantial grounds for believing that the accused person will abscond, will commit another offence, or interfere with a witness or pervert the course of justice. Now, although Article 42.2 obviously makes it harder to obtain bail in circumstances where the suspect might go out and commit another offence endangering national security, it cannot, I believe, have been the intention of the drafters of the new law that if there is no such risk, he or she should be entitled to bail, even if there is a real risk of committing another type of offence or absconding or interfering with a witness. Now, the fifth and final matter concerns the sentencing of offenders under Article 33. Apart from the introduction of tiered sentencing ranges and mandatory minimum sentences, which are not uncommon in other common law jurisdictions, Article 33 provides that a lighter sentence may be imposed or the penalty may be reduced, or in the case of minor offences, even exempted, if the defendant has, firstly, during the commission of the offence, voluntarily discontinued involvement or effectively forestalled its consequences, or secondly, voluntarily surrendered and given a truthful account of the offence, or thirdly, reported an offence committed by others, or provided information which assists in solving another criminal case. Now, although these three factors are already, to a degree, matters which can be taken into account in mitigation of sentence, they go some way, obviously, to softening the impact of the new sentencing regime. The reference, however, to, in minor cases, to a sentence being exempted is novel, and on its face it appears to conflict with the principle here in Hong Kong that a conviction comprises two parts, namely a finding of guilt and also a sentence. See the HKSAR and Ho Tung Man. However, to make sense of this, it should, I suggest, be equated with an order of absolute discharge, which can already be imposed in circumstances where a court considers that no actual penalty is necessary. In other words, a penalty which is exempted is in effect the same as an order of absolute discharge. However, the bigger issue is whether these three mitigating factors are in lieu of or in addition to the mitigating factors which already exist. If, for example, the defendant has previously led a blameless life or has acted under duress or has a mental disorder, are these factors to be disregarded henceforth? Certainly on one interpretation, that appears to be the intention, with national security cases being treated differently from others at the sentencing stage, and lesser sentences only being imposed in the three particular circumstances identified. Again, I would suggest that this is an area which will require clarification at an early stage. Thank you very much.
Ms. Cross. And I invite Professor Hua Ling Fu, who is the Dean of the Faculty of Law. Professor Fu.
Thank you for the opportunity. I will speak in English. Three general points. First, the law is here to stay. Right? The debate on whether we should have a national security legislation is over. Second point, that is a very significant legislation. It has fundamental impact on Hong Kong's legal system, the constitutional order. It need to be taken very seriously. Third, I think all agree that there are things need to be clarified. There are gaps. There may be traps. There are things that are unknown. There are things unknown. So there are lots of things to talk about. We debated on the basic law for over 10 years before the implementation. And we have very little time for this legislation. So it's extremely important to have forums like this so that people could have an opportunity to clarify some of the legal issues, identify uncertainties, and figure out a way for clarification and create certainties. We talk about restore confidence in Hong Kong's legal system, and rebuild faith in rule of law, but then before that can be achieved, there are lots of things need to be clarified. So what I do is I will identify, in my view, some of the uncertainty, the core uncertainties in the 4 offenses, and then offer some general comments on the national security law. There are 4 offenses. On secession, I think that the main difficulty is Article 22, altering by unlawful means the legal status of Hong Kong Special Administrative Region or of any other parts of People's Republic of China. So there are 2 uncertainties. One is unlawful means. Does it mean unlawful in criminal sense or in civil law sense? Right? Whether a tortious liability, for example, responsibility is sufficient for the purpose of that particular offense, or only unlawfulness in criminal sense would suffice. So that is one issue need to be clarified. The second issue, of course, is what's the meaning of legal status of Hong Kong or other parts of China. I understand if one advocates, say, to develop one country to system in Tibet, may amount to secession because that alters Tibetans' legal status. I'm not quite sure how that case would apply in Hong Kong, right? If we say we alter the legal status of Hong Kong, so there's no one country, 2 systems, there's one country, 1 system. That would alter Hong Kong's status. Would that amount to secession? I doubt that's the case, right? So in any event, I think that article would require clarification. On subversion, again, there's the issue of unlawfulness. What the unlawful means, again, it's not very clear unlawful in criminal sense or otherwise. Of course, we have this general concern of 22.1 overthrowing, undermining the basic system of the PRC established by the Constitution. It is, of course, the local Chinese Constitution is very clear. The socialist system, or the basic system, is the leadership of Communist Party. Whether that need to be fleshed out is also an issue need to be addressed. On terrorism, the key concern is Article 27, especially for people in the university writing on the moral justification of violence, right? Some of the legal theorists would have some concern, say, to what degree one can talk about the morality of violence and terrorism in an academic sense. Right. So that is a general concern about incitement. Finally, on collusion with foreign countries, that the 2 Article 29.2, right? The issue of seriously disrupting the formulation and the implementation of laws and policies, those are broadly framed offenses and need to specified. And finally, 29.5, right? Provoking by unlawful means hatred among Hong Kong residents towards the central government and the government of Hong Kong. Those are, of course, issues of significant concern, especially in the academic community. So one thing which I think we could say or should say is that we have doubt. There are things that is uncertain what the law actually covers. But there, I think we are also confident, it is on my part, that there are areas the law would not cover, right? All the offenses require is action-oriented, right? It requires very specific intent and also very specific purpose. It punish the people who endeavor to achieve certain objectives specified in the law. It punishes advocacy, right, for the for certain action to achieve certain objectives that the law prohibits. What I want to emphasize is that there is a line, right? There is a line between a normal, regular academic discussion on issues, on political issues, right? On the justification of lack of it, of violence as an academic subject, between that and advocacy, right? Unless a person writes and teaches for the purpose of inciting others to take certain immediate action, then the law does not cover. So that is a point I would want to emphasize. Finally, I just want to raise three general concerns about the law moving toward the future. I think it is quite clear that the legislation will be in Chinese and Chinese only. Correct me if I'm wrong, I think that's the only legislation in Hong Kong without an official English version. So what's the meaning of that? Moving forward, are we looking to a future that will have common law in Chinese, right? That will be, seems to me, a fundamental change. Maybe it's a small change, but I think it's quite decisive. If that's the case, it has lots of implications in the proceedings. The second issue is the relevance of the Chinese criminal law. I think over 60 to 70% of the terms, the wording in the offenses are lifted from the Chinese criminal code, right? So do they have the same meaning? The offenses are drafted differently, and some of them are fundamentally different. Subversion, for example, is very different. In Hong Kong, there is the requirement of the use of force and unlawful means. Right? That is not there in the Chinese criminal code. So that is a significant differences. In the terrorism offense, for example, the Chinese criminal law tend to put fundamentalism and the terrorism together. I think this is quite decisive and significant that in the Hong Kong law, fundamentalism is not mentioned. It's just pure terrorism, using violence to achieve a political agenda. So that is one of the key differences. But yeah, when it comes to secession, subversion, To what degree we should refer to the Chinese law, a Chinese practice. Right? China has well-established practice of prosecuting subversion. Should we note their legal doctrines, right, for guidance? If the Chinese law is not binding, I'm sure it is not. To what degree it is persuasive, right? Should the prosecution invite Chinese criminal law experts to explain what subversion is in the mainland, and then and make that interpretation relevant to Hong Kong practice? So that is the second concern. The third concern, I think, is more, I think, is quite real. Is I think that is the only legislation in Hong Kong, one single legislation that would be used by both Hong Kong judges and mainland judges, right? Because we have the Article 55, which could trigger national jurisdiction, and actually the judges will be looking at the same legislation. Since the law will be in Chinese, since the law will be interpreted by the Standing Committee in China, so are we on this converging path? So in the future, are we talking about, when it comes to national security, the rules of practice or whatever will be more or less the same, right? In Chinese, guided by the interpretation from Beijing, and the judges do they share their notes, compare their experiences? Because after all, we're talking about the same offenses, the same legislation, right? Guided by the same the authority of interpretation. So I guess I just want to make the point finally is it may be very significant to have an official version of the law. Otherwise it will be very difficult. If you look at the translation we are having now, it's not accurate. Right? I'll just give you one example on the offenses. There is the secondary participation, incites, assist in, abets. I mean, actually, if you compare, that is not accurate translation. Especially particularly the third verb, abets. In Chinese, it is 教唆. I think 教唆means, I think if you translate to English, it should be counsel, right? It's not abet, it's more immediate. So I think that's quite a significant differences. Actually, the English version narrows it down. The Chinese version is much broader. But there are many other issues with the translation. I think unless we have at least a translation provided by, in Hong Kong, by the DOJ, it will be far better. We're talking about restore confidence, right? Rebuild faith in rule of law. If a part of the community in Hong Kong cannot even understand what the law is, accurately, then we will be in great difficulties. I will stop here. Thank you.
If I may now invite Mr. Thomas So, who is the past president of the Law Society of Hong Kong and member of the Constitutional and Human Rights Committee of the Law Society of Hong Kong. Thomas.
Thank you.
Also keep it on.
Yes, I will keep my time, 5 minutes. I'll be short because what I intend to say is from the practicing lawyer's perspective, having heard a lot of feedback from clients in the business community particularly, in light of the release of this particular law. First, I would like to say this from the outset. About this piece of law itself, we have heard experts just now saying that it's an international, is a national law, but at the same time applicable in Hong Kong. And I personally would see the passing of this piece of legislation as a very important step taken by the Central People's Government to actually prove that the Central People's Government is very serious about abiding the one country, two system. And this piece of legislation is a symbol to show that the Central People's Government is serious about it. Now, the reason I say this is this. This piece of legislation is there to protect national security of our country by using the two system involving some minor cases, some small amount of cases using PRC system, but large amount of cases still use the Hong Kong SAR system to deal with it. So this, in my view, is an example of using one country as a common theme to connect the two systems. So this is a very important, I think, symbolic step taken by our government, Central People's Government, which acts as a bridging between the two systems, particularly legal system, under one theme. And the common theme is protection of national security of our country, but using different systems. Acknowledging the two systems are different, but as long as you are using your system to serve the common theme, which is protecting national security, that is fine to our Central People's Government. So that, I think, is very important, and I echo some of the experts' view, particularly Ms. Leung just now. This is a very important bridge linking the two systems, and we are here, of course, can raise issues, can raise recommendations. There are ways to refine this bridge, to make this bridge work better. But what we should not do is to create unnecessary obstacle to block the bridge. Otherwise, that is a very important step taken, and we should try and make it work. And then I will now turn to some of the issues that I have seen and I have heard from people from our legal profession and also from clients relating to this law, which I will be short. First, I think that bearing in mind this piece of law is both a national law and also a Hong Kong law, and bearing in mind Article 62 that talks about that this law shall prevail over inconsistent Hong Kong law. Now, some people misread this as this law replaced Hong Kong law, which is not right. I think what Article 62 says is that we still use the Hong Kong law, but where there are Hong Kong laws that are inconsistent with this law, then we will use this law. So it's, again, a combination of this national law plus the existing Hong Kong law. But in case of inconsistency, we adopt this law. Now, this is therefore important, as Professor Fu just now raised, that the four main offenses that we talk about, actually they exist in the PRC criminal code for a long time. And there have been definition, interpretation of what those terms means. And it would be useful, and I won't say that they are necessarily binding on our Hong Kong courts. When a case comes before Hong Kong court, where they are required to look at the terms of this law, it would be useful, I think, to consider the mainland position and consider the mainland law. So what I've been telling my colleagues in the profession and also many of the in-house counsel is that considering this law, it would be useful to consider both Hong Kong law aspect and at times also the relevant PRC law concepts behind it. But I'm not saying that they are necessarily binding, but it would be useful because ultimately the power of interpretation of this law rests in the Standing Committee. And the Standing Committee has been issuing interpretation, I think, over the years on the criminal law. Certain of the section about theft, about criminal conduct and all that. It would be useful. And second is that the four offences of particular concern to many of the in-house counsel representing the business community here, particularly, I think, of concern to them are situations where the companies might be dragged in inadvertently into possible offences. For example, the supporting role. We just heard Professor Fu talk about providing pecuniary support, providing finance, assist in bets. That exists in Article 21, 23, 26 in terms of the subversion, in terms of secession, in terms of the terrorist organization. They all have an offense relating to a supporting role. So that is important, I think, from the business community to take into account and ensure that a more stringent, I would say, internal compliance mechanism be put in place in the company to ensure that the company will not be inadvertently dragged into that kind of saga. And Article 29 is of particular concern to many of the multinational companies having a presence in Hong Kong, as well as foreign companies having their branch in Hong Kong. Now, 29.3 talks about, for example, directly or indirectly receiving instruction from a foreign country or an institution outside Hong Kong, outside PRC, outside Taiwan, Macau, to commit one of the following acts, and one of those acts is imposing sanction against Hong Kong, SAR, or PRC. Now, everybody knows that some countries already impose sanction against Hong Kong and against PRC. And some of those companies having headquarters in those countries might be duty-bound to follow their own country's order. And because of the relationship between the headquarters and the branch office here might be duty-bound to follow. And so they might fall foul under this particular section. But there are ways to adjust it. One suggestion is that they might think of, if they really still want to stay in Hong Kong and do business, they might adjust the internal guideline between the headquarters and the branch office to make sure one of the usual terms is that subject to local compliance of law applicable in the branch office jurisdiction, then they carry out the instruction from the headquarters. Then you have a safeguard. Right. I know the time is up, so I think that's what I would say today. Thank you.
Thank you, Thomas, for keeping in time. My apologies to Professor Michael C. Davis, because actually, Thomas, I should have asked him to go first, but because he was in line of sight, I missed him because he was behind me in the screen. So my apologies, Professor Michael Davis. You should have gone first, and I think I've sent you a message on the Zoom line apologizing. So may I please invite Professor Michael C. Davis. He's a senior research scholar at the Weatherhead East Asia Institute of Columbia University and a global fellow of the Woodrow Wilson International Center in Washington, D.C., USA. Professor Davis, I think you're online.
Thank you. Can I be heard?
Yes, clearly.
Okay. Okay. I hope you'll be understanding of me, since you'll see that I've written a lot, perhaps opposing this law. And there's been 6 speakers, all on one side, and it seems I'm alone on the other side. So I'll try to explain my concerns. I like to say that as a constitutional scholar, it is my general view and my general approach to try to ask what a constitution tries to do, and then to measure whatever goes on under it accordingly. In this case, the one country, two systems model obviously aimed to facilitate the return of Hong Kong to mainland China, but it also, the two systems was put in place to protect Hong Kong from the intrusion of the mainland system. And that's very clear. If you read the basic law, there's a lot of language that tries to do that and tries to keep mainland institutions out of Hong Kong. In one area, several areas would be very important in having this model. One was a area of national security. There was clearly a concern in drafting the basic law and the one country, two systems, shall we say, firewall to protect free speech in Hong Kong. So the basic law protects free speech. If you look at the basic law, there are about 16 human rights listed in the basic law, also in the joint declaration, and half of them relate to free speech in one form or another. So it was very important. The other area that the one country, two systems model tries to protect is the rule of law. And that also is discussed a lot in the basic law, from maintaining the common law to independence of the courts and so on. So what I've done, because of the time constraints, I've come up with a list of areas where I think this new law poses concern for the rule of law. And I appreciate my colleague, Professor Fu Hualing's comments. He's a very old and dear friend. And I appreciate that he says, well, the law exists already. But I would like to emphasize that while it exists in Hong Kong, much of the world is judging what they want to do about it, what they think about it. Whether this is foreign companies, as just brought up a moment ago, or whether it's universities, academics, the media, everybody is trying to decide and watching what happens in Hong Kong. So I wish it were over, but I doubt that it is. So when it comes to the rule of law, I've come up with a list I want to draw to your attention, and I'll do it very sharply because of time limits. I can tell our colleagues in the media if they want to talk to me further, because it's around midnight here where I'm at, they can email me, and they can find a usable email at the Wilson Center. Just Google Michael Davis and the Wilson Center. So I'll leave that to media to consider whether they have questions. So I'm going to get this list really sharply. First one, Hong Kong's autonomy is clearly challenged by this law, in the first place, just by ramming it through and imposing it on Hong Kong completely unseen until it's promulgated. This certainly caused a lot of concern in Hong Kong and abroad. Second, the national security law specifically says it's superior to all local laws, including presumably the Hong Kong Bill of Rights Ordinance. So I would say, given also what Maria Tam said, that this law is effectively an amendment of the basic law. It has the same status as the basic law. In fact, if anything, it may have a higher status, because under China's national legislation law, it is the last enacted, and it's more specific. Now, another thing, the national security law, as Maria Tam also pointed out, is not subject to constitutional judicial review. That is, courts cannot declare any part of it invalid. And there's no constitutional judicial review on the mainland. So again, the usual expectation about a law, especially a criminal law, that the courts could evaluate whether human rights are being violated under it, is taken away, at least as to the text of the law. Number 4, the National People's Congress Standing Committee is vested with the power to interpret this law. This leaves us with question, what is left for the courts? If we want to preserve rights, as it says in Article 4 of the law, how can the courts do this? What leeway will they have? And when will they be overridden? Fifth, a select panel of judges is selected, and many of these judges effectively can be removed if the judges are said to make statements or behave in a way that endangers national security. Well, how could a judge endanger national security? Presumably by what he says in court, he or she says in court. And so in effect, a judge will feel a great deal of pressure in the use of language under this, that they may be dismissed from the selected judges that are on the panel to hear cases under the law. Number 8, the Committee on Safeguarding National Security under this law is not subject to judicial review. It says so expressly. So again, the independence, the ability of the courts, the rule of law under the common law means that judges can evaluate laws and they can evaluate the actions of officials. So if that is diminished, then that's a problem. Then number 9, the committee can make and implement rules not subject to judicial review. We already got 2 sets of regulations under the law and query whether a court could evaluate them as violating freedom of expression, that most precious of rights that one country, 2 systems should protect. Number 10, the committee has done in effect, created warrantless searches, seizures, and surveillance. And all of this without possible judicial oversight in some cases where the police or authorities are allowed to do it on their own. And number 11, the committee is under the supervision of the Central People's Government. So this is a local committee of Hong Kong being supervised by the Central People's Government. Next, the committee has mainland national security advisor. While someone said that this person is just an advisor, given the supervision of the Central People's Government and also the Office on Safeguarding National Security in Hong Kong, many people will think this advisor is more the supervisor of the committee. And then next, of course, is the establishment of the Office on Safeguarding National Security. This profoundly challenges autonomy in Hong Kong because this office is given direct authority to act in Hong Kong vis-a-vis Hong Kong people and to investigate them, to have secret investigations, all sorts of things. I mean, for many people in the world and in Hong Kong, this is a frightening thing that you in effect have secret police in Hong Kong going around investigating people. And the next one, in performing their duties, they are not subject to local jurisdiction. Of course, that would presumably include judicial review. And next, the Basic Law Article 23 route of protection against mainland national security is involvement is completely removed. There must have been a reason that they asked that the Basic Law 23, under that law, that national security laws be enacted in Hong Kong on their own. And obviously that was because there was a concern about direct application of mainland national security laws. And now that hasn't been done. I would say as a footnote here, quite frankly, the Hong Kong government could have easily done it if they simply complied with the International Covenant on Civil and Political Rights when they proposed the law and they properly issued a white paper and everything explaining their approach. So it's really on the Hong Kong government that this wasn't done. Paradoxically, these mainland officials, I should note, may not even be subject to mainland criminal law. Query whether if they shoot somebody in Hong Kong in the exercise of their duties and they were thought to commit homicide, whether they would be accountable at all, because while there is such a thing as nationality jurisdiction in China to reach mainland citizens everywhere, there's a prohibition of applying mainland's homicide laws in Hong Kong. So I don't know if they're subject to law at all. Okay, and also, of course, the vague terms by which they can remove a case from Hong Kong. And I don't think anybody has any illusions that if someone is sent to the mainland to be tried, that they're going to have the same rights protection and the same criminal procedure protection as they would have in Hong Kong. That's very doubtful. And also the office, the mainland office oversees all local national security work, including the Hong Kong Committee and the police, I presume, and justice and so on. Who knows how far their reach is? I think a lot of people in Hong Kong and around the world are concerned about this. And what role for mainland security officials in preparing a local case? If a mainland official investigating national security is involved in turning up a local case, will they be subject to review in the courts when the matter is being tried locally? if they violated the rights of the defendant. It's not clear that they will because they're not subject to jurisdiction. So presumably they will not. And how should a local judge who faces appointment removal respond to official statements made by this mainland office? I would suggest to you that that will be very intimidating. And finally, just on the rule of law aspect, this extraterritorial application of this law to the world is extraordinary. While people around the world may have extraterritorial laws in some areas, generally they do not apply. In fact, the mainland national security law does not reach someone who's acting legally in their own country. So this one doesn't have that limitation. So if I'm acting legally, petitioning my Congress about how it should treat Hong Kong, then I could be in violation of this law, even though I'm exercising my civil rights in the United States. Now, I would add there's a number of human rights concerns as well. The mainland system was thought to offend local human rights. That's why we have two systems. Does anyone really believe that human rights will be fully protected in those mainland trials? Is that what has happened to mainland human rights defenders? It's like a spouse abuser saying, I will not do it again. In practice, these substantive laws will mean what mainland officials want them to mean. Legal boundaries are much less precise on the mainland. So people like Pu Zhichang, for example, an activist lawyer, was convicted of picking quarrels for 3 Weibo protests. Will Hong Kong people who protest things on Facebook be subject to being convicted of subversion for innocent statements that have no consequence? And without question, vague laws are subject to NPC interpretation, will have a chilling effect on local speech. Foreigners can be prosecuted for collusion for legal free speech in their own country. The law ignores the ICCPR Johannesburg principles that would require imminent unlawful action to occur. It has no comment on that. Should youngsters be sent to jail for life for merely speaking passionately or throwing rocks? Collusion appears to be so broad that it might include even petitioning the Human Rights Committee or working with foreign human rights advocacy groups. Given China's historic treatment of human rights defenders, arresting 250 of them in 2015, the so-called 709 crackdown, might the right to legal defense be undermined in Hong Kong under this law? Can a defense lawyer's offices be searched? Direct rule in the most sensitive area in Hong Kong undermines autonomy needed to protect human rights institutions. Can 2 systems survive without autonomy? And my area, especially of concern, is academic freedom. When will collaborating with a foreign colleague on a sensitive topic amount to collusion? Will hosting an international conference with critical participants amount to collusion or incitement to collusion when such encourages hatred just because of what you say, even though you don't intend it, but you might be accused of inciting? Now, what about this panel itself? We have at least 2 foreigners criticizing the national security law. This is a very passionate topic. Might our criticism inspire hatred among some elements who are listening? Could that amount to some form of incitement? Does joining the panel, this panel, with foreign individuals subject all panelists to charges of colluding? Does it subject the Law Society to such coarse charges? Of course, nobody would think so, given the participation. But what about a less famous panel on campus? So this, I think, is a very important concern. And now, while Beijing can worry about separatism, let's face it, 2 million people marched in Hong Kong with 5 demands, and none of them were separatist. is all of Hong Kong to be branded with separatism because a few hotheads started screaming things, even though they had no capacity to carry it out. They're just making, I guess, expressing their frustration. And so this, I think, is an important concern. And I think it's an important concern that, as Maria Tam, I think, in effect, may have hinted, this law is effectively superior to the basic law. So I'll close at that. I encourage any questions. Like I say, I'm an academic. What I do for a living, I look at countries, especially emerging democracies, and I ask what kinds of institutions they have and why they're important. And when I look at this, it seems like now Hong Kong has moved from a kind of two systems constitution to a national security constitution. And I think this is causing concern, and this concern is not going to go away unless some kind of behavior convinces people that these threats are not real. Thank you for your listening to my comments.
Professor Davis, thank you so much for your input in this. Very interesting from an international perspective. Thank you very much. So I'd like to move on to our last speaker. Mark Daly cannot make it, unfortunately. I wish he had made it, but my apologies. But he is, I think, online anyway. He should be. So Mr. John Clancy is a member of the Constitution and Human Rights Committee of the Law Society of Hong Kong. John, I'll ask you to speak. Thank you very much.
Okay, I'll be speaking in English also. Now, I'd like to make some very provocative statements rooted in the basic law to have some more discussion on this. First of all, Article 23 of the Basic Law says very clearly that Hong Kong Special Administrative Region shall enact laws on its own to prohibit acts of treason, secession, sedition, subversion, etc. Nowhere in Article 23, or for that matter anywhere in the Basic Law, does it state that if the Hong Kong government does not do this within a certain period of time, does the central government have the right to step in and enact such a law. Hong Kong residents have a legitimate legal expectation that protections entrenched in the Basic Law will continue to be protected. Now, I want to read out quite a few sections of the Basic Law, and I think you will see that these are in contrast to some of the things in the new national security law. 1. Under Article 8, common law precedents subject to any amendments by the legislation of the Hong Kong SAR. And that does not include mainland law, but it's common law precedents be taken into consideration. Article 19 of the Basic Law. The Hong Kong SAR shall be invested with independent judicial power, including that of final adjudication. The courts of the Hong Kong SAR shall have jurisdiction over all cases in the region, and shall have no jurisdiction over acts of state such as defense and foreign affairs. Nothing about national security. The personnel of all offices set up in the HKSAR, be departments of the central government, shall abide by the laws of the region. All people set up in Hong Kong from the national government shall abide by the laws of the region. Hong Kong residents shall have freedom of speech, press, publication, etc. You know all that. Joint demonstration, right to strike, etc., right to form unions, etc. The freedom of the person of residence shall be inviolable. Arbitrary and unlawful search of the body or resident or deprivation of the freedom of the person shall be prohibited. Arbitrary or unlawful search or intrusion into a resident's home or other residence shall be unlawful. Hong Kong residents shall have the right to confidential legal advice and access to the courts, choice of lawyers for timely protection of their lawful rights. Hong Kong residents shall have the right to institute legal proceedings in the courts against the acts of the executive authorities and the personnel. Rights and freedoms enjoined by the Hong Kong residents shall not be restricted unless as prescribed by law, and shall not contravene the provisions in the international covenants, Article 39. The principle of trial by jury, previously practiced in Hong Kong, shall be maintained, Article 86. In criminal or civil proceedings of the HKSAR, the principles previously applied in Hong Kong and the rights previously enjoyed by the parties to proceedings shall be maintained. The Standing Committee of the National People's Congress shall authorize the courts of the Hong Kong to interpret on their own in adjudicated cases the provisions of the law which are within the limits of the autonomy of the region. The chief executive of the Hong Kong SAR shall be responsible for the implementation of the Basic Law, and other laws which are in accordance with the Basic Law shall apply to Hong Kong SAR. Article 48(2). Article 2 of the National Security Law states that Articles 1 and 12 of the Basic Law are the fundamental provisions of the Basic Law. But Article 12 very clearly refers to the high degree of autonomy, which is spelled out more in detail in Article 2 of the Basic Law. The Hong Kong SAR is authorized to exercise a high degree of autonomy and enjoy executive, legislative, and independent judicial power, including that of final adjudication. Article 5(2) of the National Security Law, a person is presumed innocent until convicted by a judicial body. However, that presumption does not apply to persons who are not permanent residents in this new national security law. Article 34(2) of the security law says, a person who is not a permanent resident of the region may be subject to deportation if he or she contravenes the provisions of the law, but is not prosecuted. This also pushes aside the role of the courts in upholding the law in Hong Kong. Article 12 of the National Security Law, the HKSAR shall establish a committee for safeguarding national security, which committee shall be under the supervision not of the chief executive, but under the supervision and accountable to the Central People's Government. I'd like to note that there's no such provision in the law that was passed by the Macau SAR. According to Article 15 of the National Security Law, the committee shall have a national security advisor to be designated by the Central People's Government to provide advice to the committee. Again, no such provision in the law passed by the Macau SAR. Chapter 5 of the National Security Law is in regards to the establishment in the Hong Kong SAR of an office for safeguarding national security of the Central People's Government. Article 19 of the law allows the Financial Secretary of the HKSAR, upon approval of the Chief Executive, to appropriate from the General Revenue a fund for safeguarding national security. This is not subject to any restrictions in the relevant provisions in laws in the region. Does this exclude provisions in a basic law under which a legislative council has a power and function, quote, to examine and approve budgets introduced by the government and, quote, to approve taxation and public expenditure? Article 73(2) and 3 of the Basic Law. Thank you. Does this also ultimately exclude the power of the Hong Kong courts? Article 42 sets aside the presumption of the right to bail, which you've heard earlier today, and states that no bail should be granted to a suspect unless a judge has sufficient grounds for believing that the criminal suspect or defendant will not continue to commit acts, thereby going against what is set out very clearly in the Bill of Rights Ordinance. Article 43(7) allows the police to require a person who is suspect on reasonable grounds of having in possession information or material relevant to an investigation to answer questions and furnish such information or produce such material. A number of solicitors have asked me whether this applies to solicitors. Journalists are also concerned. If a solicitor or journalist has been instructed to represent a person in a civil or criminal case, does a solicitor have to provide confidential, legally privileged information to the authorities? Does a solicitor have to answer questions that would breach his duty of confidentiality? Likewise, in place are well-known freedom of the press and the desire for the journalists to keep their sources confidential. Does this apply to journalists? According to Article 58 of the National Security Law, a criminal suspect shall have the right to retain a lawyer. It notably does not state a lawyer of his or her choice, as does so in the Basic Law. As Hong Kong does not have jurisdiction, are the suspects entitled to have a Hong Kong lawyer or only a lawyer from the mainland? The further question is, when does a suspect have access to a lawyer? According to Article 58 of the law, it is, quote, from the day he or she first receives inquiry by the office or from the day a mandatory measure is taken against him or her. Who decides? the office, or the suspect. Some powers of the Hong Kong courts entrenched in the Basic Law have been set aside. Like other members of the Law Society, when attending international meetings, I have always stressed that Hong Kong maintains a strong rule of law that protects the rights of residents, which greatly supported by an independent judiciary. A former Secretary for Justice in one article, when referring to the rule of law in Hong Kong, cited comments that I had made at one international meeting. Will we continue to be able to make such strong statements about the rule of law in Hong Kong? Can we continue to make strong statements about protection of human rights in Hong Kong? According to Article 14 of the law, decisions made by the committee shall not be amenable to judicial review. The Hong Kong courts do not have jurisdiction in regards to offenses under the circumstances set out in Article 55 of the law. In regards to Article 55 circumstances, Article 57 states, the criminal procedure law of the People's Republic of China and other related national laws shall apply to procedural matters. Thus, the jurisdiction of the Hong Kong courts and protections of the Basic Law are set aside. There is no right of the court of the there is no right of the court of the accused to ask the Hong Kong courts to ensure that all legal requirements for rendition have been satisfied. So the person doesn't have access to a Hong Kong court in regards to rendition. For the avoidance of any doubt, Article 60 of the law states, the acts performed in the course of duty by the office and its staff, in accordance with this law, shall not be subject to the jurisdiction of the Hong Kong SAR. Further, the articles, including vehicles by the holder, shall not be subject to inspection, search, or detention by law enforcement officers of the region. Now, what about the traffic accident of dangerous driving and somebody being killed? The Hong Kong courts are not allowed to intervene. What about corruption by these officers? And just two more points. Article 44 of the law sets the terms of the designated judges at 1 year. There's a good amount of academic discussion as to whether short terms of judges contribute to potentially undermining their independence. Judges can be disqualified if they make statements endangering national security. Does this include statements made in previous judgments or statements made in open court by a judge? The criticism that I have heard most often is the vagueness of many provisions of the law. There are not the clear definitions that we're used to in reading laws. In fact, there are no definitions as such in the national security law. Thus, the absence of certainty demanded by the common law leaves Hong Kong residents in a fog of uncertainty about the boundaries of lawful behavior. This has not been assisted by senior government officials publicly stating that certain actions may be offenses under the national security law. The last thing I'd like to maybe join in later on in discussion is the whole issue of English, whether or not it should be official language or whether official law should be passed in Hong Kong in an English language. Those are my comments. Thank you, Chairman.
Thank you very much. Thank you all the speakers for participating, putting forward your views. It's been very useful for our members that are applying on Zoom. But I know that there's been quite a few comments, and I'm sure that some of you have some response to make on each of the comments. So perhaps you can start. CMO Director.
我中文講幾句啦。咁因為我哋都好高興啦，有好多唔同嘅意見喺個 panelist 嗰啲 speaker 講者講咗出嚟嘅。咁我諗俾少少時間啦，或者直至到11點10幾個字啦，等 speakers 我哋講者之間去回應翻其他講者所講嘅嘢。咁我哋而家可以開始睇下，我首先邀請有冇在座任何人有想回應嘅嘢先。蘇會長。
I just want to just one point that maybe is useful to reply to a few points made by John just now. In circumstances where the Central People's Government will take jurisdiction of a matter under Article 55, and then thereon, I think the provisions set out very clearly that the PRC criminal procedure law applies. Now, many of those terms that set out in the other article, Article 56, Article 57, about legal right to have legal representation, and when a suspect can see his lawyer. All that actually are there under the criminal procedure law that applies in the PRC, including the measures that the law enforcement agencies may take against a suspect and all that. So that goes back to my first suggestion just now when I was saying that when we look at this law, it would make more sense, I think, particularly where situation under Article 55 applies, to at the same time also look at the applicable PRC law. That would actually help us clear a lot of uncertainties or misunderstanding that certain terms have been deliberately vague and all that. And I therefore urge people, also take a look at the relevant PRC law in order to make more sense out of the relevant terms of the law that particularly applies to a situation where the Central People's Government will take jurisdiction over the matter.
Any other? Yeah, Maria, thank you.
I'll just respond to 3 points. The first point is about whether the NSL actually amends the basic law. The answer is that the NSL is to protect the whole of China, including Hong Kong. And it's not just to protect Hong Kong. So it is a national law on its own, but particularly written and passed in order to make sure that Hong Kong is also protected. Article 23 remains a constitutional obligation for the SAR government to fulfill, and we hope it will be soon. The second group of question is about human rights. As you know, in Hong Kong, in our courts, it's well established that Johannesburg Convention and the Syracuse Principle are observed. And when we cite cases as precedents, we take into consideration common law country cases, not Chinese cases. And the test has always been on necessity and proportionality. If you look at all the articles in the convention in respect of freedom of assembly, speech, or whatever, there's always a qualification, and I'm only going to cite a few, that should limitation could be prescribed by law, it has to be necessary. It may be for protection of public safety, order, health, or morals of the fundamental rights and freedom of others. Variation on the same theme throughout those articles. So I'm going to answer in one group, and that is, we have a long practice here to follow the common law precedents. The third group of cases is in respect of what happens in China. I think those people who have also come out and criticized the validity of this law or the legitimacy of this law because of certain cases they heard about China. Now, I have no first-hand information to comment on those cases, but I think it is very important if we look at each country in order to protect its national security, they employ different types of laws and measures to do it. I've just looked at the United States. I think they have 20 laws, and they are very detailed, so much so that, to cite a few, you have laws that protect financial secrets, cyber law, communication, homeland safety. We have no Guantanamo Bay in Hong Kong or China. And then you have the Patriot Act, you have the Logan Act. If we look into it, you'll find that they are far more restrictive and stringent than the NSL you're looking at now. So please do not criticize another country by using your own measures. I think it is a United Nations convention that you respect other countries' sovereignty and not to intervene. I am not saying that this law, as it is now, will not be subjected to adjudication and court cases. In fact, that was the first sentence I said. There's no law in the world that would not attract litigation. So let us let the law work. The idea is to deter rather than punish. And it's important now in Hong Kong to have this law. If you're here and you experience what happened in the last 12 months. Thank you for the questions.
Yeah. Any other speakers who'd like to comment? Elsie, yes.
Yes, may I respond briefly to the question of firstly, judicial independence. Now, the appointment of judges by the chief executive does not roll into the judicial independence, because what is it meant by judicial independence is that judges are free to adjudicate on cases without any interference by anyone. It is, in fact, a criminal offense if anybody tries to intervene with the decision of judges. That is also ensured by our system for appointment of judges, which is on the recommendation of Judicial Officers Recommendations Committee. And that, in fact, all the judges are already on this basis. So when the chief executive appoints judges, is those which have been approved or supported by the Judicial Officers Recommendations Committee. Now, although the chief executive can appoint judges, can designate judges, but firstly, she cannot assign a particular judge to hear a particular case. That power remains with the chief judge of the High Court and the chief justice of the Court of Final Appeal. And she has no power to remove the judge. It's only upon expiry of the term of 1 year, the chief executive cannot renew, they can refuse to renew the appointment. Upon a dismissal of judges has to be on the ground of inability to carry out duties and or misbehavior. And even in such cases, it has to be investigated upon by a panel of 3 judges. And so the appointment of judges will not interfere with the judgment which the judge will make, and it does not affect judicial independence. Now, the second point I would like to respond is to supplement what Maria has said. The national security has always been given an important place when you talk about human rights. Human rights are not absolute. This freedom of speech, freedom of expression, freedom of demonstration and possession and so on may be restricted if prescribed by law when it's necessary to protect national security, public security, and so on. And, but the restrictions must be proportionate for the purpose. You can see that recently in the case of the prohibition against face covering regulation. Now, the court make a very different judgment in the case of lawful assembly and lawful possession and those which are unlawful. The court held that in the case of lawful possession and demonstration, that you should not, the restriction is disproportionate. It doesn't satisfy the test of reasonableness. But in the case of the unlawful possession and so on, that the restriction would be reasonable. So you can see our court is very experienced in dealing with the restrictions against those freedoms and so on. And I don't think that the ordinance had any impact on this. This is already the human rights situation in Hong Kong. Freedoms and fundamental rights are protected. but they are not unrestricted. And it has to be it has to be prescribed by law and is proportionate to the purpose. So I don't think that it would erode into our human rights, the human rights in Hong Kong. So I leave it to the other speakers to respond.
Any other speakers like to respond on what the others have said? No.
Can I respond?
Professor Davis, yes.
Oh, yes. With all respect to our colleagues in the panel, I think the trick is not just that we convince the people that agree with us, but the international community is watching, Hong Kong people are watching. I think, in fact, why Hong Kong people are concerned and why most people are concerned is because the courts of Hong Kong have, in fact, been quite good at upholding the rule of law and human rights. And so the concern right now is whether that capacity is being undermined by the introduction of transfer of cases to the mainland, by the restrictions on judicial review for national security officials on both Hong Kong committee and the office, the mainland office, and all the mainland officials that are sent to Hong Kong. So it's not enough to convince, I guess, ourselves and, everyone actually agrees that Hong Kong's human rights conditions have been quite good. The question is, should we have continuing confidence given the rather vague language of the laws that are applied, given the sort of overriding of the historical idea of one country, two systems to keep some of these more difficult areas of mainland law out of Hong Kong. I think moving the mainland national security apparatus into Hong Kong is going to raise question. And it seems, and I tried to point out, that in many areas it'll be difficult or for the courts to constrain it, either because there's no jurisdiction to do so, to review the officials' acts, or in fact, probably because some degree of intimidation that will occur. I mean, we haven't seen how this law is going to be carried out, and we're all going to be watching, but it's not encouraging. I know just today there was attacks on the opposition political organizations for having a primary. Primaries are basically ways of narrowing down candidates. And generally, it's not considered a coup d'etat simply to win an election. And so people watch that, they hear that. That doesn't encourage a kind of narrow view of this. So I think that's the problem. It's not convincing us that Hong Kong has good judges and that Hong Kong has a tradition of the rule of law. That's exactly why people are concerned, at least the people that I talk to.
Thank you, Professor Davis. Any others? Yes, Professor Fu?
I think, Michael, I think all the panel members probably agree more than you think. We probably were looking at a different dimension. Of course, there are concerns. Otherwise, we'll not be here. There are some aggrieved concerns. Not only lawyers, I guess friends in the media, in the university, they're all concerned. The issue is how to address those concerns, right?
I agree.
55 jurisdiction, it is scary. It's unprecedented. No one has imagined that is coming. Then the question is how to deal with it. I think Ronnie has mentioned a few ways. That you have 3 conditions. Can we clarify? Can we narrow it down? Right? Is the better way to convince people to maintain the confidence in rule of law? So those are the challenging time. Yes, we can't always criticize. We are criticizing, but at the same time, here on the ground, We just have to deal with those issues in front of us. I guess that's why what I'm saying at the very beginning, the law is here, right? It's at the stage of implementation. The issue is not, or don't want to have it, but the only choice for us here is, in looking forward in the process of implementation, how things can be done better. I mean, that is the whole purpose. So in that sense, I think most of us are on the same page, even though we came from different perspectives. Thanks.
Discussing with CM what. So if any other questions, I have one question for each of you. If you've all if you all completed, then what I'd like you all to consider is, and I'll ask each one of you in response. So I'd like each of you to consider just 2 points. One, and keep it very short. One good point and one bad point, or one positive, one negative, doesn't have to be good and bad, about this law, either generally or for lawyers, because this is for lawyers. So if you could please consider, and I'll ask each one of you just in short to say one good point and one. Is that okay, Madam President? Yes. So anyone would like to start? Yeah, Thomas. You have the shortest time to speak because I pushed you.
Yeah.
So I'll give you first.
I go first.
Yes.
As lawyers, obviously, good point is this piece of law generate business for a lot of lawyers. That definitely.
You don't want to tell the press that.
Compliance advice. I was just saying a lot of people because of this piece of new law. Now, actually, when one looks at a piece of new laws, generally it will generate a lot of responses from business community because they need advisors to kind of adjust their behavior to fit with this new law. And this new law is, although it talks about protection of national security, if you ask me, is more or less the same as when the AML legislation came out many years ago. A lot of businessmen were worried about AML. Oh, how should we adjust our behavior from now on in order not to breach the law? I mean, it's more or less the same. So that is one good point, I think. Second, I think bad point is obviously I think that when particularly for Hong Kong lawyers, we might need to probably learn a bit more about the mainland system, about the mainland law, in order to make sense of how this piece of legislation actually works. And I was quite surprised because I had two summer interns came to me this summer. And I asked them, have you learned constitutional law in university? And they said, yes. I said, well, what subject do you learn? They said, basic law. I think, what about our PRC constitution? They said, it's out of the syllabus. Now, I think we need, going forward, we really need to encourage our younger generation lawyers, our law students, apart from just stopping at the level of basic law, they need to learn a bit more about our country's constitutional framework.
It's a bit like the European Convention. So, Professor Davis, I forgot you last time, so may I ask you to comment on your 2 points? If you have, if not, I'll ask somebody else and then come back to you.
Yeah, I don't have much good to say about the law.
Okay.
But,
so give me 2 bad points.
Yes, bad points I made about 20 of them in my opening presentation. But I think the strongest concern I have is I think the way this law has been positioned, it really weakens the role of the judiciary, either directly by saying there's no jurisdiction to decide this or that, or by a kind of intimidation of the judiciary that, if you don't say the right thing, then you're violating national security and you're likely to be removed from this panel. Now, anyone could respond to me and say, well, nobody will do that except exceptional cases. It'll be narrowly applied, just like people said about this law already, that it's going to be narrowly applied. And then we're told almost on the first week that people, even having a primary to narrow down their candidates, were somehow subversive. So there's a real kind of danger of too many cooks in the kitchen giving out opinions in ways that will cause concern among ordinary people, whether they be local or international. And this could result in Hong Kong's itself being diminished in its capacities in a number of ways.
So no good points then? Not even one?
I don't, this particular law I think was unnecessary, so I don't have any good points for
Very
it.
well. Okay, thank you, Professor Amos. Maria, can I ask you if you're ready?
Good point about this law is that it has no retrospective effect. Let bygones be bygones. We come to the stage when a family is sitting together over dinner at home because of political issues. We just sort of slam on the table and walk out. We don't want that to last in Hong Kong. We have to look at each other face to face and say we are one family. I hope this law will put aside a lot of differences and Hong Kong will start afresh. As to bad point, I don't see bad points. I accept all the criticisms that's been made around the table, and I appreciate their concern, and I thank those questions for making us more aware of possible shortcomings. I think there is another good point. Hong Kong has survived many difficult times. Before reversion of sovereignty, the Time magazine says Hong Kong is dead. We didn't die. We thrive until about a few years ago when we have this internal strife over political aspirations, which given time, the younger generation will take over from us anyway. It's a pity that it was done in such a hurry. So I think another good point, instead of saying there is a bad point, is that we will prove to the world that here we will still continue to have rule of law and we'll still go on a one country and system and survive. That would be my comment.
Elsie, would you like to go first?
Well, the bad point first. The bad point is we have a lot of homework. Professor Davis and John have raised more than 30 questions. I think I have answers to many of them, but we have to explain to people why this would not, they need not worry about it. So there is a gap in understanding. A lot of people do not understand the contents of the law as yet, nor its implication. So I think is obligations on lawyers, particularly, to explain to the public what it is and deal with the concern. The good point is this is the hope for Hong Kong people to, for the society to return to peace and order. We had enough of it for the last 13 months. And without dealing with without this law, then we have no hope of the proceeding to resolve other issues like including democratic development, as the society is so split and life disrupted. I think it is necessary for Hong Kong to return to peace and order before we deal with anything else.
Professor Fu?
So bad things first.
Sure, as you like.
I guess the law in general
Just one,
for the short term would there will be self-censorship among professors, researchers, students because of the uncertainty and the concerns. It will stay for a while unless we could rebuild confidence. It may disappear for a while. Good things, actually, I do like Article 4 and 5. I don't think it's just an empty slogan, it's more than rhetoric. Especially if you put, this is the Chinese legislation, that is the first time in the PRC's history to state those principles clearly in a Chinese law. It will have some ripple effect on other Chinese legislation. So I'm looking at, even with that legislation, I'm still looking at the possibility for Hong Kong to offer a model for the Chinese law in the future.
，Professor Fu。
So
Is this a bit like the European system when England went into Europe? They have a combination of civil law and common law. Interesting academic. Ron, do you want to go after?
I'm sorry, but with respect, I don't think it's fair or indeed meaningful to pick a good point about law or a bad point about law. To me, as a lawyer, there are only two important aspects of any law, whether good law or bad law. One is the lawmaking process. Is it legal? Is it within the bounds of the legal regime of any particular place? The second aspect is the implementation of the law, whether the implementation is again within the confines of the legal regime of a particular case. I've already explained that the lawmaking process is within the Joint Declaration, doesn't offend the autonomy of Hong Kong within the confines of one country, two systems. I've already explained that as so far as the contents are concerned, it demonstrates a respect for the one country, two systems. But if you really want to push me to talk about good points or bad point about this entire episode, I would say the good point is that it demonstrates an attempt by the central government to strike a balance under the one country, two systems. Now, you may disagree. The balance has been properly struck. It was overly in favor of central government or overly in favor of Hong Kong. I think different people with different political inclination may have a different answer to that. But attempt has been made, and this is the result of the attempt. The bad thing about it is that, I find it quite repulsive, if you don't mind my saying so, that there are so many people in the world who would judge a law by reference to political belief or political inclination, not by reference to legal principles or what the law is all about. I don't want to pick any quarrel with any panelists, but I would like to, by way of example, just to mention one thing. Professor Davis mentioned just now that judges would be taken off the panel, and this is contrary to established principles or perhaps even the rule of law. I would like to remind everybody that no judges should express political views anyway. Even before the enactment of this law, judges have been taken off cases because they have expressed political views openly. This has got absolutely nothing to do with national security law. It is simply a question of judges must to be perceived to be absolutely neutral, without influence by his own personal political inclination. How is that contrary to the rule of law? It would be quite contrary to the rule of law if you allow judges to say publicly in relation to one side of the coin or the other side of the coin, particularly in relation to politics. This is wholly, totally unacceptable. And yet, this point had been made the subject of severe accusations and criticisms of the SAR government and the central government the world over, many, many times. And this is the kind of double standard which I cannot stand. I'm sorry.
Thank you. Mr. Cross, I'll come back to you last, and I'll let John go first. Because you have some interesting points, Professor.
I think the one good point I can think of is the same as Marie, is that there's no retrospective effect to the law, which I think is good. In terms of bad, I think the main thing is that this law is a vote of non-confidence in both the executive and the judiciary, and it weakens their role in Hong Kong. I think that we have advisors coming in now for the committee. We have the office being set up. These are people who have not had the long-term experience of the history and culture and economy of Hong Kong, and we don't know what's going to be happening with this double perspective, looking at it from their own perspective. In Chinese and Cantonese, 街同鴨講. So I think we have two different levels of speaking. I think going forward, I try to be positive, and I like to be Maria. I think I've been here a while, and I think that Hong Kong will deal with this problem. I look forward to the role of the judiciary, very much so, in interpreting a lot of these laws, for those laws that at least are dealt with in Hong Kong. And I also look forward to the people of Hong Kong. I think that there's a lot of concern, anxiety, fears, troubles. At the same time, I hope there's no I hope there's no passivity. I hope people will continue to be actively involved as residents, as citizens, to speak up for demanding rights and freedoms and expressing them in unique ways within the law. I've been involved in active nonviolence for more than 60 years, and I think that's the way forward. But I saw the most recent test. I think Michael mentioned it about the primary election. We had just two levels of talking. People went ahead, and I think over 500,000 people voted. And even though there was a kind of what I would call invisible violence on the part of some people in authority. Speaking out, but people felt intimidation. So I think that I'd like to see that continuing, the spirit of Hong Kong people to handle adversity. And even though this law has a lot of, in my view, a lot of negative implications, I hope that we can find a way forward. We find a way forward in light of it.
Thank you. John. Grenville, you have the last word.
What I found encouraging was the fact that when the NPC-SC enacted this law, it adopted a minimalist approach. Obviously, as has been said, we've waited 23 years for this legislation to be enacted. And the Standing Committee could well have taken the view that as you've done nothing for 23 years, we're going to ourselves enact all the laws that are now necessary to protect national security. But they didn't adopt that approach. What they said was, we'll enact the laws which are urgently needed now in light of existential threats, and we will leave it to you to get on and enact the rest of Article 23, hopefully in the fairly near future. So that means, for example, that treason and sedition still remain matters for the local government to enact here. So the use of a minimalist approach of that type showed that the central authorities do still have confidence in Hong Kong to complete the process themselves, despite what has happened what has not happened over the last 23 years. And on the slightly concerning side, I'd really just mention what I touched upon in my opening remarks, namely the lack of particularity in certain areas, such as the way in which the three-judge panel will proceed in future, such as the issue of whether the mitigating factors that are identified are exhaustive or whether they're in addition to the current mitigating factors. So it's really that lack of particularity which is of some concern and which may require further clarification or indeed interpretations.
Thank you, Mr. Cross. So I'm going to allow CM to finish and conclude in Chinese, please.
唔該晒。時間差唔多㗎啦，但係因為呢個係一個雙語嘅論壇啦，所以我最後都用廣東話講翻一句啦。作為 moderator 咧，我就唔應該俾好多意見嘅。不過好簡單講咧，就係任何新嘅法例喺普通法制度之下立咗法之後咧，都係要經過法院有啲案例去澄清一啲事件、一啲原則嘅。國安法都唔係例外，所以社會有一啲唔同嘅睇法，有猶豫、有疑慮嘅地方，亦都係正常嘅。咁我相信未來香港嘅法院會經過一啲累積到案例之後咧，會澄清咗一啲重點嘅。最後，香港律師會作為香港其中一個最重要嘅法律團體咧，我哋係有責任向社會各階層，不單單是係法律工作者，去提供一啲場合去解釋一啲政府嘅法例嘅。而今日呢個論壇正正就係藉住呢個機會，希望可以澄清某一啲唔清楚嘅地方。咁我亦都希望律師會可以繼續去多辦呢一啲咁嘅論壇嘅。會長，你有冇嘢講？ Amir, I pass it back to you to adjourn it.
Thank you. Thank you, everyone, for attending. Thank you for participating. This is a very important piece of law. We're going to have a break now, and then we'll come back, which is a private session for the members only. So thank you for the press for coming, and thank you very much, everyone, for giving up your time.